2021, Samia Zti versus Republic of Tunisia, application number 015 of 2018, Kija, Nestory, Jinyamu versus United Republic of Tanzania, application number 023 of 2018, Rashidi, Romani, Nyerere versus United Republic of Tanzania, application number 024 of 2018, Gerald, Kalong versus United Republic of Tanzania, application number 027 of 2018, Lamic versus United Republic of Tanzania, and application number 030 of 2018, Edison Simon Mombeki versus United Republic of Tanzania. The parties were duly notified of the sitting, and some applicants are attending virtually, while the respondent state, United Republic of Tanzania, is represented by Counsel Zamaradi Johannes, Ms. Zamaradi Johannes and Mr. Stephen Kimaro, state attorneys. Thank you, Honorable President.
We'll start with the first case. Application number 112 of 2018. Glory Houssou versus Republic of Benin. And the judge who is going to read the judgment is Judge Ben Saula. And she will read or she will deliver in French.
Merci, Madame la Présidente. Donc, en l'affaire Glory Cyriaque
Houssou versus the Republic of Benin, application number 012/2018, judgment of 13th November 2024. The court, composed of Imanidi Aboud, President, Mudibu Sako, Vice President, Rafa Benashur, Susan Menge, to Jilane Chizumila, Jafika Ben Saula, Blaze Jikaya, Stella I, Anukama, Dumisa Bin, Tsembeza, Dennis Zati, Ajay, Duncan Nagaswaga, judges, and Robert Eno, registrar. A subject of the application, a fact of the matter, it emerges from the application that the respondent state parliament adopted the law of 24 August 2004 on the Code of Persons and Family of Benin, hereinafter referred to as the law of 24th August 2024. According to the applicants, Article 6, 1, 3, and 4 of the said law contravenes the instruments for protection of women's rights ratified by the respondent state. The applicant avers that on 18th December 2017, he lodged a petition with the Constitutional Court of the respondent state challenging the constitutionality of the above mentioned article. Furthermore, that the Constitutional Court declared his petition inadmissible by decision DCC 18022 of 1 February 2018, hereinafter referred to as the decision of 1 February 2018 on the grounds that the law of 24 August 2004 had already been declared constitutional by decision DCC 042004 of 20 August 2004. It emerges from the record that the law of 24 August 2004 was amended and supplemented by law number 2021-13 of 20 December 2021, hereinafter referred to as the law of 20 December 2021, after the latter was declared constitutional by decision DCC 21-321 of 10 December 2021 of the respondent state constitutional court. prayers of the parties. The applicant prays the court to find that the decisions of the respondent states a constitutional court are not binding on the court, as the court was established by an international instrument that is superior to domestic laws. Consequently, find the application admissible. Find that Article 6 of the Code of Persons and Family violates the principle of equality between men and women as established by the Charter, the Maputo Protocol, the CEDAW, and the AfCHPR. Order the respondent state to amend its legislation on the protection and advancement of women, in particular Article 6 of Law 2002-07 of 24 August 2004 on the Personal and Family Code in order to restore the rights of Beninese women. Order the respondent state to pay various expenses occasioned by the litigation, which began on 18 December 2017, in particular those relating to traveling from the town of Cote in the Wime region to the Constitutional Court and to the UPS Mail Transfer Office, both located in Cotonou. Costs in respect of research and of consulting resource persons in connection with the drafting of submissions, travel expenses from Cotonou to Arusha and from Arusha to Cotonou if the court schedules a hearing in respect of the case. Costs in respect of accommodation in Arusha during the trial. On its part, the respondent state prays the court to find that the Constitutional Court has twice reviewed the constitutionality of the individual and family code. Find that the Constitutional Court has already declared all its provisions to be constitutional. Find that the decisions of the Constitutional Court are not subject to appeal. Accordingly, hold that the application is inadmissible. Acknowledge that a child is entitled to one or more first names, but only one surname. Find that the choice of surname is a function of the established social order in each country. Find that the parentage is patrilineal in the respondent state. Find that this filiation does not violate the rights of women. Consequently, dismiss the action brought by the applicant. On the operative part, for these reasons, the court unanimously on jurisdiction dismisses the objection based on material jurisdiction, declares that it has jurisdiction to hear the application. On admissibility, it declares that the application admissible. And as the merits are concerned, by on reparation and cost of the cost, this will be the decision. The court declares by a majority of 7 votes, 4 and 4 votes, that that the matter is admissible. On admissibility, by a majority of 7 votes, 4 and 4 against, Judges Susan Menge, Tafika Bensaula, Dennis Diajay, and Duncan Gaswaga dissenting, holds that the application has become moot. On reparations, holds that there are no grounds to grant reparations. Costs, holds that each party shall bear its own costs. Signed the same bench as indicated above, in accordance with Article 28.7 of the Protocol and Rule 70, Paragraph 2 of the Rules. The partial dissenting opinion of Judges Susan Menge, Tafika Bensaula, Dennis Diajay, and Duncan Gaswaga is appended to the judgment done at Arusha this 13th day of November 2024 in French and English, the French text being authoritative.
That's the decision of the court. Judgment number 2 is on
Yeah,
case on the application number 029.
I think he can come now. Yes, I can prepare.
It's about between Musa versus the Republic of Cote d'Ivoire. And the judge who is going to deliver the judgment on behalf of the court is Judge Menge. She will deliver in French.
Merci, Madame la Présidente.
Thank you, Madam President.
Affaire Doumbia
The
Musa,
matter of Doumbia Musa versus the Republic of Cote d'Ivoire,
requête numéro
application
029
number 029/2019, ruling of 13th November 2024.
La Cour, composée
The court
de
composed of
Imani Aboud,
Imani Aboud, President,
Modibo Sako,
Modibo Sako, Vice President,
Rafa Ben Achou,
Rafa Ben Ashu,
Suzanne
Susan Menge, Tujilane
Tujilane
Chizumela,
Shafika
Shafika Ben Saula,
Blaise Chikaya,
Les Chikaya,
Stella
Stella I. Anukam,
Dumisa
Dumisa B. Nsebeza, Dennis B. Ajayi, Duncan Gaswaga, all judges, and Robert Eno, registrar.
Les faits de la cause
Facts of the
sont
matter
les suivants.
are as
Il
follows.
ressort de la requête
It emerges from the
introductive que
application
le requérant
that
a
the
été
applicant
accusé de vol à
was
réussi
arrested
commis de nuit avec
and
le usage
detained on
d'armes et
17
placé sous
October
mandat de dépôt
2024 and
le 17
subsequently charged with
octobre
gang robbery with
2014.
violence by the
Il
use
a
of
été
a
condamné
firearm.
le 31 octobre
On 31
2014
October
à 20 ans d'emprisonnement
2014,
ferme
he was
par le
convicted and
tribunal de
sentenced to
première
20
instance
years
d'Abidjan.
imprisonment with hard labor
Suite à
by the
ces
Court of First
appels,
Instance in
la
Abidjan.
Cour d'appel d'Abidjan
The
a
applicant
rendu un
appealed to
arrêt
the Court of Appeal
confirmatif
in Abidjan, which
numéro
by judgment
511 du
number
22 juin
511 of
2016.
22 June
Le
2016
requérant
upheld the
déclare
judgment of
pour
the trial
l'état
court.
de la
The applicant
procédure,
avers
il a
that he
reconnu les
admitted
faits qui lui
the,
étaient
the charges
reprochés.
against him
Le
at all
requérant
stages of
ajoute
the
que
proceedings.
pour des raisons
The
indépendantes de
applicant
sa
further
volonté,
avers that for
il n'a
reasons
pas
beyond
formé de
his
pourvoi
control,
de cassation
he did not
contre l'arrêt
file
de la
a
Cour d'appel
cassation appeal
d'Abidjan.
against the judgment of the Court
Cependant,
of Appeal in
il
Abidjan.
relève que,
However, he
n'ayant pas bénéficié de
contends
l'assistance
that
d'un
he
avocat,
was not aware
il
of
ignorait
the
l'existence de cette
existence of
procédure.
this remedy as he was not
Étant l'état de
assisted by
cause,
counsel, and that
l'exercice
in
du
any
pouvoir
event,
serait
an
sans
appeal
succès
would not
dans
prosper
l'ordre juridique
in
et
the current
judiciaire actuel
legal and judicial
déjà
system
mis en
of the
cause.
respondent state.
Les demandes des parties sont les
Prayers
suivantes.
of the parties are as
Le
follows.
requérant demande à la
The
Cour
applicant
d'ordonner les
praised the
mesures
court
suivantes:
for the following:
la grâce
a
présidentielle,
presidential pardon,
la commutation en bonne et due forme
due
de sa
and
peine
proper
d'emprisonnement de
reduction
20
of the
ans ferme
20-year
en une
prison
peine
sentence to a
de
shorter
moins lourde,
prison term,
une libération conditionnelle,
release on
un
parole,
règlement à l'amiable
amicable settlement,
et une indemnisation
and
financière du
financial
préjudice subi
compensation for
en
the
raison
damage
des
suffered
décisions
as a
judiciaires
result of the
qui ont
unfair
été
court
prononcées à
decisions
son encontre
against him,
et condamner
and
l'État défendeur à
order the
lui payer
respondent
les sommes
state to pay
suivantes:
him the following
3
amounts:
millions de francs
3
CFA
million
au
CFA
titre du
francs
préjudice
for
juridique,
legal
1
prejudice,
million de francs
3
CFA
million
au titre
CFA
du
francs
préjudice matériel
for material
et 4
prejudice,
millions de
and
francs au
4
titre du
million
préjudice
CFA francs
moral.
for
Ces
moral
deux gouvernements ont
prejudice,
déclaré
and
la requête
declare the
mal fondée,
application
non,
unfounded.
oui. L'État
I'm sorry.
défendeur prie la
The
Cour
respondent state praised
au
the court
principal de déclarer la
to
requête irrecevable
primarily declare the
et
application inadmissible,
subsidiairement de déclarer la
in the
requête mal
alternative,
fondée
declare the
et la
application
rejeter
unfounded
en
and
conséquence.
accordingly dismiss it.
Le dispositif de cet arrêt
The operative part of this
est conçu
judgment
comme suit.
is as follows.
Par ces motifs,
For these reasons,
la Cour,
the court
à l'unanimité,
unanimously
compétence,
on jurisdiction
se déclare compétent
declares that it has
sur la
jurisdiction
recevabilité,
on admissibility,
accueille l'exception
upholds the
d'irrecevabilité
respondent state's
tirée du
objection
non-épuisement
based
des
on
recours internes,
non-exertion of local
déclare la
remedies,
requête
declares the
irrecevable.
application
Sur l'état de
inadmissible.
procédure,
On
il
course,
ordonne que chaque
the court
partie
decides that
supporte
each
ses
party
frais de
shall bear
procédure.
its own cost.
Ont signé
Signed,
tous les juges dont les noms ont été
all
cités
the
plus haut,
judges whose names were mentioned
ainsi que
earlier,
le greffier,
as well as the registrar,
Robert Eno,
Dr. Robert
fait
Eno.
à Arusha
Done in Arusha this 13th day of the month of November in the year 2024
en arabe,
in English,
en français
French,
et en
and Arabic,
portugais.
as well as in Portuguese, the French text being
Je vous
authoritative.
remercie.
Thank you. Yeah. The last one.
third judgment is on application number 037 of 2020. Arun Diko versus Burkina Faso. And the judge who is going to deliver this judgment is Judge Benesho in French.
Merci, Madame la Présidente.
Thank you, Madam President.
Composé de Imani Aboud, président.
The court composed of Imandi Abu, President, Modibo Sako, Vice President, Rafa Benashu, Ugan Menge, Tijilans, Ibumila, Chafika Bensaula, Blessed Chikaya, Stella Anukam, Denis, Dumisan Sebeza, Denis Ajay, and Dom Savibasawa, all judges. In the matter, Aruna Diko, Aristide Ouedraogo, Bangobe Bakiano, Lukman Mohamud, Sawadogo, and Akado Diallo, represented by Aruna Diko, versus Burkina Faso, represented by the legal agency of the state. After deliberations, the court renders the following ruling. Parts of the matter, it emerges from the application that in July 2019, the president of the respondent state signed a decree pertaining to a national dialogue in preparation for elections scheduled to be held in 2020. According to the applicants, the dialogue, which took place from 5th to 22nd July 2019, culminated in a report. The applicants aver that on 23rd January 2020, the government tabled before the National Assembly a draft bill to amend the Electoral Code based on the dialogue report. They further aver that the said amendment of the Electoral Code was undertaken while the people in several regions of the respondent state had fled their homes and sought refuge in the regions bordering neighboring countries due to the insecurity that prevailed in the respondent state. According to the applicants, several mayors had also left their towns for the same reason. It is the applicants' contention that, despite these circumstances, on 5th February 2020, the government finalized the electoral roll and set the election date for 22nd November 2020. The applicants aver that, in response to this decision, various political actors met to discuss the issue and released a report calling for the elections to be postponed. In light of this report, the government tabled a bill before the National Assembly introducing new amendments seeking to remove the legal impediments to holding the elections on the date initially scheduled. The said bill was subsequently withdrawn on 13th July 2020 in order to foster political dialogue. The applicants further aver that on 20 July 2020, without holding a new political dialogue, and after consultations held with only a few members of the National Dialogue Monitoring Committee, the government again tabled the amendment bill before the National Assembly. The applicants alleged that on 10th August 2020, they tried unsuccessfully to have the bill rejected, after which it was finally adopted on 25th August 2020 and promulgated into law by the President of the respondent state on 28th August 2020. Pursuant to the changes that were introduced through the law, the government was empowered to invoke force majeure and exceptional circumstances to hold the elections despite the concerns raised by the applicants. On 16th of September 2020, the applicants petitioned the Constitutional Council challenging the constitutionality of the amendments to the Electoral Code. On the 16th of October 2020, the Constitutional Council dismissed the said petition for being brought against a law that had already been enacted. Prayers of the parties. In their application, the applicants pray the court to declare law number 34/2020/AN of 20 August 2020, amending law number 014/2001/AN of 3 July 2001 on the Electoral Code null and void on the grounds that the provisions of Article 148.2 and 125.2 thereof violate Article 13 of the Charter read jointly with Article 4.2 of the African Charter on Democracy, Election and Governance, Article 25 of International Covenant on Civil and Political Rights, and Article 2.1 of the ECOWAS Democracy Protocol. The respondent state did not file any submission. After considering the application and after relating to its jurisdiction and admissibility, the court rules as follows. Unanimously declares that it has jurisdiction on admissibility by a majority of 10 votes for and 1 against, declares the application inadmissible for non-exhaustion of local remedies. On cost, orders that each party shall bear its own cost. Signed, all the judges mentioned earlier, as well as the registrar, and in accordance with Article 28.7 of the protocol and Rule 71 and 2 of the rules of court, the declaration of Judge Chafika Ben-Saure is appended to this ruling, done at Arusha on this 13th day of November in the year 2024 in English and French, the French text being authoritative. I thank you, Madam President.
Until the judgment. The court has to recompose of its bench because one of our colleagues has to recuse herself. Judge Chizimila from Malawi, because the following judgment is against Malawi. Application number 001 of 2022. We saw the Charles Tanzania versus Republic of Malawi. And this judgment is going to be delivered by myself, the president of the court in Malawi, in English. The court composed of Liman Aboud, President Modibo Sako, Vice President Rafa Benchu, Susan Menge, Chafika Ben-Saure, Blaise Chikaya, Stella Ayanikam, Dumisa Bin Sebeza, Dennis Lee Ajay, and Duncan Gaswaga, judges, and Robert Emerald, the registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights on the establishment of the African Court on Human and People's Rights, hereinafter referred as the Protocol, and Rule 9, Sub 2 of the Rules of the Court, hereinafter referred as the Rules, Justice Tujilane R. Chizumila, member of the court and a national of Malawi, did not hear the application. After deliberation by the court, the court decided the following. The facts of the matter. It emerges from the application that on the 1st March 2018, the applicant was extradited from South Africa to the respondent state. He was arraigned before the High Court of Malawi, Zomba District, and charged with the murder of Miss Linda Gaza, contrary to Section 209 of the respondent state penal code. The said murder allegedly occurred on or before 4th August 2010 at Mukebe in Mangochi district. The charge was later amended to include the offenses of hindering the burial of a dead body contrary to section 131 and perjury contrary to section 101 of the respondent state's penal code. Before the High Court, the applicant filed a notice of motion on preliminary issues, seeking declarations concerning alleged violations of statutory and constitutional provisions. This was dismissed by the High Court on 23rd January 2020. Subsequently, the applicant filed a notice of appeal together with an application for a stay of the High Court proceedings and pending determination of his appeal before the Malawi Supreme Court of Appeal. On 27th January 2020, the High Court dismissed the application. The dismissal was subsequently upheld by the Malawi Supreme Court of Appeal on 22nd July 2020. On 28th August 2020, the High Court convicted the applicant for the offenses of murder, hindering the burial of a dead body, and perjury. He was sentenced to life imprisonment for murder, 2 years imprisonment for hindering the burial of a dead body, and another 2 years imprisonment with hard labor for perjury. The sentences to run concurrently. He later appealed to the Supreme Court of Appeal, which upheld the conviction and sentence on 14th July 2021. Prayers of the party, the applicant prays the court to declare, first, to declare or find that his right to fair trial guaranteed under relevant human rights instruments has been violated, and that such violation occasioned miscarriage of justice. Second, order restitution by way of restoration of his liberty and or release from prison. And last, order compensation to be assessed by the court. The response state did not file any response and therefore did not make any prayers. On the default of the respondent state, in the instance case, the applicant was served on the respondent state as earlier stated. The application was served to the respondent state as earlier stated. However, the respondent state neither appeared nor filed any response, even after being reminded to do so as recounted above. The court finds that all requirements under Rule 63 are met and proceeds to render the present judgment in default. On operative parts, for these reasons, the court unanimously and in default on jurisdiction declare that it has jurisdiction. On admissibility, declares that application is admissible. And on merits, first hold that the respondent state did not violate the right to fair trial protected under Article 7 sub 1A of the Charter as read together with Article 8 of the UDHR. Part A, Article 2J, and Part C, Article B, Roman 1 of the Fair Trial Guidelines regarding right to be heard by MSA holds that The respondent state did not violate the right to fair trial protected under Article 7.1 of the Charter as read together with Article 4 sub 1 of the SDH, Article 8 of UDHR, Article 14.1 of the AfCHPR, and Part A, Article 2H of the Fair Trial Guidelines regarding the applicant's conviction. Or hold that respondent state did not violate the rights of fair trial protected under Article 7.1 of the Charter as read together with Article 8 of UDHR, Article 14.1 of AfCHPR, and Part 1 and Article 2E of the Fair Trial Guidelines with regarding to being given adequate opportunity to challenge opposing evidence. The court further holds that the respondent state did not violate the right to fair trial protected under Article 7.1b of the Charter as read together with Article 11.1 of the UDHR, Article 14 sub 2 of the AfCHPR, and Part N, and Article 6E of the Fair Trial Guidelines with regard to the right to be presumed innocent. Also holds that the respondent state did not violate the right to fair trial protected under Article 7.1 of the Charter as read together with Article 4 sub 1 of the ACDEC, Article 14.3a of the AfCHPR, Article 8 of UDHR, and Part N, Article 1A of the Fair Trial Guidelines with regard to being notified of the charge. The court further holds that the respondent state did not violate the right to fair trial protected under Article 7.1 of the Charter as read together with Article 14.1 of the AfCHPR, Article 8 of UDHR, and Part A, Article 2, Roman 1 of the Fair Trial with regard to be given reasons for court decisions. On reparation, the court dismisses the applicant's prayer on reparation. On costs, orders that each party shall bear its own costs. This judgment is signed by the bench, the judges as stated above. Done at Arusha, this 13th day of November in the year 2024 in English, the English version being authoritative. This is the judgment of the court. The court is going again to compose its bench to allow Justice Chizumila to come in and join the bench. Oh, and Justice Chizumila will join the bench, and Justice Benashu, who is a nation of the Republic of Tunisia, will recuse himself. Following judgment number on application number 016 of 2021, Samia Zti versus Republic of Tunisia. This judgment is going to be delivered by Judge Sako, the Vice President of the court, and it will be delivered in French.
Affaire Samia Zti.
Matter of Samia Zti versus the Republic of Tunisia, application number 016/2021, judgment of 13 November 2024. The court composed of Imani D. Aboud, President, Modibo Sako, Vice President, Suzanne Menge, Tijulane R. Chijumila, Shafika Ben Saula, Blaise Chikaya, Sarah I. Alukam, Mr. P. Nsebesa, Dennis Diaje, Duncan Gassaga, Judges, and Robert Eno, Registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 9.2 of the Rules of Court, hereinafter referred to as the Rules, Justice Rafa Ben Ashu, member of the court and a national of Tunisia, did not hear the application. Facts of the matter, Samia Zti, self-represented, and after deliberations, renders the following judgment. The parties, Dame Samia Zti, hereinafter referred to as the applicant, is a national from Tunisia. She challenges the regularity of the Constitution of 1st of June 1969 through a decree law of 21st of March 2014 without a referendum on the Constitution of 27th January 2014. The application is against the Republic of Tunisia, then after referred to as a respondent state, which became a party to the African Charter, hereinafter referred to as a charter on 21st of October 1986, and to the protocol on the 1st of October 2016. The respondent state has filed the deposit of the application in hereinafter referred to as a declaration, has filed the declaration accepting the jurisdiction of the court to receive applications from individuals and non-governmental organizations. Subject of the application, facts of the matter, it emerges from the application that after the President Ben Ali was ousted as President of the Republic of Tunisia in January 2011, his successor, the acting President Paul Mebaza, took oath of office by which he swore to respect the 1959 Constitution, then enforced in the country. A few days thereafter, he announced that it was no longer possible to abide by this Constitution, and subsequently passed Decree Law of 23rd of March 2011, reorganizing the public powers. On the 16th of December 2011, the National Assembly passed the law on the provisional organization of the public authorities, which complemented the provisions of Decree Law of 23rd March 2011 and concentrated powers in the hands of the President of the Republic, the President of the National Constituent Assembly, and the head of government. It also emerges from the application that the adopted decree laws sought to deprive the Constitutional Court of its prerogatives until the adoption of a new constitution on 27 January 2014 by the National Constituent Assembly without prior popular consultation by means of a referendum. The applicant avers that since then, a feeling of discontent and disenchantment has persisted among the Tunisian people, has borne out in the collapse of the rule of law, disintegration of its institutions, constitutional stalemate, political crisis, violence of all kinds, and increasing crime. It was against this backdrop that she brought the case before this court, challenging the adoption of a constitution without consulting the people and denouncing the violation of the Tunisian people's right to self-determination. Prayers of the parties. The applicant praised the court to find that the respondent state violated the supremacy of the Constitution, declare that the 1959 Constitution is still in force and applicable, and order that it be implemented. Declare that the 27 January 2014 Constitution is null and void. The respondent state praised the court to declare that it lacks jurisdiction to hear the application, declare that the application does not satisfy the admissibility requirement under Article 56(5) of the Charter, dismiss the application and all of the applicant's claims. For these reasons, the court unanimously on jurisdiction dismisses the objection to jurisdiction, declares that it has jurisdiction. On admissibility, dismisses the objection to
admissibility based on non-exhaustion of local remedies. By a majority of 8 votes for and 2 against, holds that the application was filed within a reasonable time, declares the application admissible, and on merits, holds that the respondent state did not violate the people's right to self-determination protected by Article 13 of the Charter in relation to the adoption of the 27 January 2024 Constitution through the Constituent Assembly, holds that the respondent state violated the independence of the judiciary protected by Article 26 of the Charter by interfering in the promotion and discipline of judicial officers, holds that the respondent state violated the principle of separation of powers in relation to the executive's interference in the sphere of the legislative. On reparations, holds that the request for to unify the 27 January 2014 Constitution is moot, declare that the prayer to re-establish the People's Representatives Assembly is moot following the 17 December 20 and 29 January 2023 elections. Orders the respondent state to take all necessary measures to operationalize the Constitutional Court within 6 months from the date of notification of this judgment. Orders the respondent state to repeal Decree Laws number 2022 of 12 February 2022 and number 2022-35 of 1st January 2022, and to reinstate the High Judicial Council within 6 months of notification of this judgment. On implementation and reporting, orders the respondent state to submit to it within 6 months of notification of this judgment a report on the status of implementation of the measures contained therein, and thereafter every 6 months until the court considers that there has been full implementation. On course, orders that each party shall bear its own course. Signed, Liman Abud, President, Modibo Sako, Vice President, Susan Nenge, Judge, Tujilane R. Zumila, Judge, Shafika Ben Salah, Judge, Blaise Chikaya, Judge, Stella Nukam, Judge, Umisa B. Isebesa, Judge, Dennis D. Ajay, Judge, Duncan Gaswaga, Judge, and Robert Eno, Registrar. In accordance with Article 28(7) of the Protocol and Rule 71 and 2 of the Rules of Court, the individual dissenting opinion of Judge Modibo Sako, Vice President of the Court, and Judge Blaise Chikaya are appended to this judgment, done at Arusha, this 13th day of November in the year 2024 in Arabic, English, and French. The Arabic and French texts both being equally authoritative.
This is the judgment of the court. We'll proceed in the court. Will compose its bench by Judge President, Judge Samia Zti, to recuse herself and allow Justice Rafael Benashir to come in.
Requête numéro 15-2018, Kija, Nestory, Jinyamu contre la République unie de Tanzanie. Le présent arrêt sera lu par l'honorable juge
Shall be read by Judge Sebesa.
Thank you, Mr. President. On this, the 13th day of November 2024, I read the judgment in the matter of Kija, Nestory, Jinyamu, versus the United Republic of Tanzania in application number 015/2018. The court is composed of Muki, Vice President, Rafa Benashur, Susan Mengwe, Tujilane R. Chizumila, Shafika Bensaula, Blaise Chikaya, Stella I. Anukam, Tunisia Binzabeza, Dennis D.J., Duncan Gaswaga, judges, and Robert Ino, the registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 9(2) of the Rules of Court, hereinafter referred to as the Rules, Justice Imani Diabod, President of the Court and the National of Tanzania, did not hear the application. The subject of the application, facts of the matter. It emerges from the record that on the 23rd of August, 1999, the applicant was found in possession of 22 heads of marked cattle belonging to one Masigana Nundu, who had been murdered alongside his wife, Nsamaka Chilala, and daughter-in-law, Ngwalo Khela, on 20 August 1999 at Mwangi village within the district and region of Shinyanga. He was arrested, charged with the 3 different counts of murder, and tried before the High Court in Tabora. On 21 September 2007, the High Court found that the applicant guilty of murder on all the 3 counts under the doctrine of recent possession and sentencing to death by hanging. The applicant appealed against this decision before the Court of Appeal at Tabora, which dismissed the appeal on 18 April 2013 as baseless. He then filed an application for review of the decision of the Court of Appeal, which was also dismissed on the 23rd of August 2017. The alleged violations were that the applicant alleged the violation of his right to a fair trial, owing to the fact that his conviction was allegedly based on evidence that was not substantiated. The respondent state did not file any pleadings before this court. On the subject of default of the respondent state, I read that Rule 63(1) of the rules provides that whenever a party does not appear before the court or fails to defend the case within a period prescribed by the court may, on the application of the other party or on its own motion, enter judgment in default after it has satisfied itself that the defaulting party has been duly served with the application and that all the other documents pertinent to the proceedings have been duly served. The court notes that the aforementioned Rule 63(1) sets out 3 conditions for granting a judgment in default, namely 1, where the party does not appear before the court or fails to defend its case within the period prescribed by the court. 2, where the court is satisfied that the defaulting party has been duly served. And 3, upon the court's own cognizance or where another party applies for judgment in default. The required conditions having thus been fulfilled, the court hereby proceeds to issue this judgment. by default. And in its operative part, the court, for these reasons, unanimously and in default on jurisdiction, declares that it has jurisdiction. On admissibility, declares that the application is admissible. On the merits, holds that the respondent state did not violate the applicant's right to a fair trial under Article 7.1 of the Charter. By a majority of 8 judges, 4 and 2 judges against, Justices Dumisa bin Sebeza and Blaise Chikaya dissenting, holds that the respondent state violated the applicant's right to life protected under Article 4 of the Charter in relation to the mandatory imposition of the death penalty by failing to allow the judicial officer's discretion to take into account the nature of the offense and the circumstances of the offender. Holds that the respondent state violated the right to dignity and not to be subjected to cruel, inhuman, or degrading punishment and treatment guaranteed under Article 5 of the Charter in relation to the imposition of the death penalty by hanging. Unanimous on reparations, pecuniary reparations, does not grant reparation for material prejudice. Awards the applicant the sum of 300,000 shillings, Tanzanian shillings, for moral prejudice suffered. On non-pecuniary reparations, court dismisses the applicant's prayer for release. Orders the respondent state to revoke the death sentence imposed on the applicant and remove him from the death row. Orders the responding state to take all necessary measures to remove within 6 months of the notification of this judgment the mandatory death penalty from its laws. Orders the responding state to take all necessary measures within 1 year of the notification of this judgment for the re-hearing of the case on the sentencing of the applicant through a procedure that does not allow the mandatory imposition of the death sentence and oppose the discretion of the judicial officer. Orders the respondent state to take all the necessary measures within 6 months of the notification of this judgment to remove hanging from its laws as the method of execution of the death sentence. On our publication, the court orders the respondent state to publish this judgment within a period of 3 months from the date of notification on the websites of the Judiciary and the Ministry for Constitutional and Legal Affairs, and to ensure that the text of the judgment is accessible for at least 1 year after the date of publication. On implementation and reporting, the court orders the respondent state to submit to it within 6 months from the date of notification for the judgment a report on the status of execution of the orders set forth herein, and thereafter every 6 months until the court considers that there has been full implementation thereof. On the costs, the court orders that each party shall pay its own costs. This judgment is signed by Modibo Sako, Vice President, Rafa Benashur, Judge, Susan Mengwe, Judge, Vigilani Architmila, Judge, Shafika Bensala, Judge, Blaise Chikaya, Judge, Stella Anukan, Judge, Tunisia bin Sabeza, Judge, Dennis Dia J, Judge, Duncan Gaswaga, Judge, and Robert Ino Registrar. In accordance with Article 28(7) of the protocol and Rule 70(3) of the rules, the declarations of Justice Blaise Chikaya and Justice Tunisia bin Sabeza are appended to this judgment. This is done at Arusha this 13th day of November in the year 2024 in English and French, the English text being authoritative. I hand down the judgment, Mr. President.
Quelle est la décision de la
And
Cour?
that is the decision of the court. Application number 023/2018, Rashidi Romani Nyerere versus United Republic of Tanzania. The judgment shall be read by Judge Ajay.
Thank you, Mr. President. In the matter of Rashidi Romani Nyerere versus the United Republic of Tanzania, application number 023 of 2018, judgment 13th November 2024. The court, composed of Modibo Sako, Vice President, Rafa Benashu, Susan Menge, Tujilani R. Chisumira, Chafika Ben Saula, Grace Chikaya, Stella I. Anukam, Dumisa B. Intebisa, Dennis D. Ej, Duncan Kaswaga, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol of the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, the Rule 92 of the Rules of Court, hereinafter referred to as the Rules, Justice Imani D. Abode, President of the Court and the National of Tanzania, did not hear the application. Facts of the matter. It emerges from the record that 8 August 2008, the applicant murdered one Sale Nyerere Nwambiga in Swaya village within Ruanga district in Mbeya region. On the same day, the applicant was arrested and subsequently charged with murder before the High Court sitting at Mbeya. On the 1st October 2013, the High Court found the applicant guilty of murder and sentenced him to suffer death by hanging. The applicant filed an appeal to the Court of Appeal sitting at Mbeya, which dismissed his appeal on 3rd September 2015. Prayers of the parties. The applicant praised the court to find that the respondent state violated Articles 1, 3, 4, and 5 of the Charter and to quash his conviction, grant him reparations. In relation to jurisdiction, the respondent state praised the court to declare that it is not vested with jurisdiction to adjudicate the matter before it. In respect of admissibility, the respondent state praised the court to find that 1, the applicant has not met the admissibility requirements to fulfill the conditions under Rule 45 of the Rules of Court, or Article 56(5) and Article 6(2) of the Protocol. 2, the application is inadmissible. 3, the application be dismissed in accordance with Rule 38 of the Rules of Court. Then 4, the cost of this application be borne by the applicant. On the merits and reparations, the respondent state praised the court to find that 1, they did not violate the provisions of Articles 4 and 5 of the African Charter on Human and People's Rights. 2, the application be dismissed for lack of merits. 3, the applicant continues to serve his sentence. 4, the applicant's prayers be dismissed. 5, the cost of this application be borne by the applicant. The operative part. For these reasons, the court unanimously on jurisdiction dismisses the objection to its material jurisdiction, declares that it has jurisdiction. On admissibility, dismisses the objections to the admissibility of the application, declares that the application inadmissible in respect of the allegation of prolonged police detention before the trial made by the applicant, declares the application admissible in respect of the allegation of violation of the right to a fair trial by reason of the admission of unlawfully obtain evidence, and the right to dignity due to his alleged torture. On merits, holds that the respondent state did not violate the applicant's right to a fair trial under Article 7.1 of the Charter. Holds that the respondent state violated Article 1 of the Charter by a majority of 8 judges, 4 and 2 judges against Judges Brace Chikaya and Dumisa B. Nsebisa, dissenting on the issue of the death penalty. The court further holds that the respondent state violated the applicant's right to life under Article 4 of the Charter due to the mandatory imposition of the death penalty. Holds that the respondent state violated the applicant's right to dignity under Article 5 of the Charter by reason of prescribing hanging as a method of execution of the death penalty, unanimously on reparations, on pecuniary reparations, dismisses the applicant's claims for pecuniary reparations, grants the applicant damages for the moral prejudice he suffered, and awards him the sum of Tanzanian shillings 300,000. Orders the respondent state to pay the sum awarded above, free from tax, as fair compensation to be made within 6 months from the date of notification of this judgment, failing which it will be required to pay interest on arrears calculated on the basis of the applicable rate of the Central Bank of Tanzania throughout the period of the delayed payment until the amount is fully paid. On non-pecuniary reparations, dismisses the applicant's prayer for the question of his conviction. Orders the respondent state to revoke the mandatory death sentence imposed on the applicant and remove him from death row. Orders the respondent state to immediately take all necessary measures within 6 months to remove the mandatory death penalty from its penal code as it impinges on the discretion of the judicial officers in imposing sentences. Orders the respondent state to take all necessary measures within 1 year of the notification of this judgment for the rehearing of the case on the sentencing of the applicant through a procedure that does not allow the mandatory imposition of the death sentences and oppose the discretion of the judicial officer. Orders the respondent state to take all necessary steps within 6 months as from the date of notification of the judgment to remove from its laws hanging as a means of execution of the death penalty. Orders the respondent state to publish this judgment within a period of 3 months from the date of notification on the websites of the judiciary and the Ministry for Constitutional and Legal Affairs, and ensure that the text of the judgment is accessible for at least 1 year after the date of publication. Implementation and reporting. The court orders the respondent state to submit to it within 6 months from the date of notification of this judgment a report on the status of implementation of the decision set forth herein, and thereafter every 6 months until the court considers that there has been full implementation thereof. On cost, orders that each party shall bear its own cost, signed by all the judges aforementioned together with registrar. In accordance with Article 28(7) of the protocol and Rule 73 of the rules, the declarations of Justice Brace Chikaya and Justice Dumisa Nsebisa are appended to this judgment. Done at Arusha, this 13th day in the year 2024 in English, French, Portuguese, and Arabic, the English text being authoritative. Thank you, Mr. President.
Telle est la décision de la Cour. Requête numéro 24-2018, Gerald Kalong contre la République unie de Tanzanie. La juge qui va prendre la parole pour à présent délivrer le jugement est l'honorable juge Liman. Vous avez la parole, s'il vous plaît.
Thank you, Honorable President. This is the matter of Gerald Kalong versus United Republic of Tanzania. Application number 024/2018, judgment of today. The court, composed of Modibo Sako, Vice President, Rafa Ben Ashur, Susan Menge, Tujilane R. Chizumila, Chafika Ben Saula, Blaze Chikaya, Stella I. Anukam, Dumisa Bin Sebeza, Dennis D. Ajay, Duncan Gaswaga, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, and Rule 9.2 of the Rules of Court, Justice Imani D. Aboud, President of the Court, and a nation of the United Republic of Tanzania, did not hear the application. Facts of the matter. On 5 February 2008, at Ilolo village within Rungwe district in Mbeya region, Henry Mwakajila, a person with albinism, disappeared and was never seen again. The police, acting on a tip on diverse deaths in May 2008, arrested the applicant and 4 other individuals who are not parties to this application. According to the record, during the applicant's arrest, he was found to be in possession of body parts, which were later proven to belong to the missing Henry Mwakajila. The applicant and his co-accused were subsequently charged with the murder of Henry Mwakajila. On 30 June 2015, the High Court of Tanzania, sitting at Mbeya, found the applicant and 3 of his co-accused, guilty of murder and sentenced them to suffer death by hanging. One of the applicant's co-accused was acquitted, however. Aggrieved by the conviction and sentence, the 4 convicts appealed to the Court of Appeal sitting at Mbeya. On 12 October 2017, the Court of Appeal confirmed the conviction and sentence of the applicant and one of his co-appellants, while acquitting the other 2 appellants. Prayers of the parties. The applicant prays the court that his application be allowed and his conviction and sentence of death be set aside after quashing the whole conviction. He also prays that he be released from prison and that the respondent state should compensate him since he was illegally convicted to suffer death by hanging. In relation to jurisdiction and admissibility, the respondent state prays the court to order that, 1, the Honorable African Court on Human and People's Rights is not vested with jurisdiction to adjudicate over this application. 2, the applicant has not met the admissibility requirements stipulated under Rule 45 of the Rules of the Court or Article 6.2 of the Protocol. 3, the application is inadmissible. 4, the application be dismissed in accordance to Rule 38 of the Rules of Court. 5, costs of this application be borne by the applicant. On merits and reparations, the respondent state praised the court to order that, 1, it has not violated the rights of the applicant under Articles 3, 2, and 5 of the African Charter on Human and People's Rights. 2, it did not violate the rights of the applicant provided under Article 7.1 of the African Charter on Human and People's Rights. 3, the application be dismissed for lack of merit. 4, the applicant not granted, should not be granted reparations. 5, the applicant continue to serve their sentence. 6, the applicant's prayers be dismissed. 7, the costs of this application be borne by the applicant. The operative part. For these reasons, the court unanimously on jurisdiction dismisses the objection to its material jurisdiction, declares that it has jurisdiction. On admissibility, dismisses the objection to the admissibility of the application, declares the application admissible. On merits, holds that the respondent state did not violate the applicant's right to equality and equal protection before the law as provided for in Article 3 of the Charter. Holds that the respondent state did not violate the applicant's right to a fair trial as provided in Article 7 of the Charter. Holds that the respondent state did not violate the applicant's right to enjoy family life as provided under Article 18 of the Charter. Holds that the respondent state did not violate the applicant's right to free movement provided under Article 12 of the Charter. By a majority of 8 judges for and 2 judges against, Judges Blaise Chikaya and Dumisa bin Sebeza, dissenting on the issue of the death penalty, holds that the respondent state violated the applicant's right to life under Article 4 of the Charter due to the mandatory imposition of the death penalty. Holds that the respondent state violated the applicant's right to dignity under Article 5 of the Charter by reason of prescribing hanging as a method for execution of the death penalty. Unanimously on reparations, on pecuniary reparations, dismisses the applicant's claims for pecuniary reparations, grants the applicant's prayer for damages for moral prejudice he suffered, and awards him the sum of 300,000 Tanzanian shillings. Orders the respondent state to pay the sum awarded above free from tax as fair compensation to be made within 6 months from the date of notification of this judgment, failing which it will be required to pay interest on arrears calculated on the basis of the applicable rate of the Central Bank sentences. Orders the respondent state to take all necessary measures within 1 year of the notification of this judgment for the rehearing of the case on the sentencing of the applicant through a procedure that does not allow the mandatory imposition of the death sentence and upholds the discretion of the judicial officer. Orders the respondent state to take all necessary measures within 6 months from the notification of this judgment to remove hanging from its laws as a method of execution of the death penalty. Orders the respondent state to publish this judgment within a period of 3 months from the date of notification on the website of the judiciary and the Ministry for Constitutional and Legal Affairs, and ensure that the text of the judgment is accessible for at least 1 year after the date of publication. Implementation and reporting orders the respondent state to submit to it within 6 months from the date of notification of this judgment a report on the status of implementation of the decision set forth herein and thereafter every 6 months until the court considers that there has been full implementation thereof. On costs, orders that each party shall bear its own costs. This judgment is signed by the judges and the registrar mentioned earlier on. In accordance with Article 28(7) of the protocol and Rule 73 of the rules, the declarations of Judges Blaise Chikaya and Dumisa Bin Seveza are appended to this judgment. Done at Arusha, this 13th day of November in the year 2024 in English and French, the English text being authoritative. Thank you, Mr. President.
Telle est la décision de la Cour. Requête numéro 24-2012 vient d'être lue. À présent, requête numéro 27-2018, Lamic Basile contre la République unie de Tanzanie. L'honorable juge Gaswaga va nous faire lecture du jugement. Gaswaga, vous avez la parole.
Thank you, Mr. President. In the matter of Lamic Basile versus the United Republic of Tanzania, application number 27 of 2018, judgment delivered on the 13th day of November 2024. The court, composed of Modibo Sako, Vice President, Rafa Benabiu, Susan Mengi, Tujilani R. Chizumira, Chafika Ben Saula, Blaise Chikaya, Stella I. Anukam, Dumisa B. Seveza, Dennis D. Ajay, Duncan Gaswaga, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol of the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, wherein after referred to as the Protocol, and Rule 9, Sub-Rule 2 of the Rules of Court, wherein after referred to as the Rules, Justice Liman G. Abod, the President of the Court and the Nation of Tanzania, did not hear the application. Facts of the matter. It emerges from the record that on the 21st day of September 2008, the applicant and his father-in-law, Pancras Minago, now deceased, killed the latter's neighbor, Miss Magdalena Andrew, who was a person with albinism, by using a machete. Subsequently, they were arrested and charged with murder on the 26th day of November 2015. On 27th October 2016, the applicant and his father-in-law were convicted of murder by the High Court of Tanzania sitting at Bukoba and sentenced to death by hanging. Dissatisfied with the conviction and sentence, the applicant on 31st July 2017 filed an appeal to the Court of Appeal of Tanzania, which dismissed the same on 4th September 2018 for lack of merit. Prayers of the parties. The applicant prays the court to 1, quash his conviction and sentence, 2, order his release from prison, and 3, grant him costs. The respondent state did not participate in the proceedings and therefore did not make any prayers. The operative part of this judgment. For these reasons, the court on jurisdiction unanimously and in default declares that it has jurisdiction. On admissibility, declares the application admissible. On merits, unanimously holds that the respondent state did not violate the applicant's right to have his cause heard, protected under Article 7, Sub-Article 1 of the Charter with regards to his conviction. By a majority of 8 judges for and 2 judges against, Justice Blaise Chikaya and Musa dissenting on the issue of the death penalty, the court holds that the respondent state violated the applicant's right to life protected under Article 4 of the Charter in relation to the mandatory imposition of the death penalty, and holds that the respondent state violated the applicant's right to inherent dignity protected under Article 5 of the Charter in relation to the method of execution of the death penalty. Unanimously, on reparations, the court dismisses the applicant's prayers for reparations. The court orders the respondent state take all necessary measures to remove within 6 months of the notification of this judgment the mandatory death penalty from its laws. Orders the respondent state to take all necessary measures within 1 year of the notification of this judgment to vacate the sentence, remove the applicant from death row, and rehear his case on sentencing through a procedure that allows judicial discretion. Orders the respondent state to take all necessary measures within 6 months of the notification of this judgment to remove hanging from its laws as the method of execution of the death sentence. Orders the respondent state to publish this judgment within a period of 3 months from the date of notification on the websites of the judiciary, the Ministry for Constitutional and Legal Affairs, and ensure that the text of the judgment is accessible for at least 1 year after the date of publication. Further orders the respondent state to submit to it within 6 months from the date of notification of this judgment a report on the status of execution of the orders set forth herein, and thereafter every 6 months until the court considers that there has been full implementation thereof. On costs, the court orders each party that each party shall bear its own costs. This judgment is signed by all the judges and the registrar whose names have been earlier on pronounced, in accordance with Article 28, Sub-Article 7 of the protocol, and Rules 70, Sub-Rule 3 of the rules. The declarations of Justice Blaise Chikaya and Justice Musa are appended to this judgment. done at Arusha this 13th day of November in the year 2024 in English and French, the English text being authoritative. Thank you, Mr. President.
Telle est la décision de la Cour. Requête numéro 30 2018, Edison Simon Mwamboki contre la République unie de Tanzanie. Le présent arrêté lu par l'honorable juge Anokan.
Merci, Juge le Vice President. I deliver the judgment in the matter of Edison Simon Ubike versus the United Republic of Tanzania. Application number 030/2018. And the judgment is dated the 13th day of November 2024. The court composed of Modibo Sako, Vice President, Rafa Benashu, Susan Menge, Tijilan Aro Chizumila, Shafika Ben Saula, Blaise Shikaya, Stella I. Anukam, Domisa B. Sabiza, Dennis Diaje, and Duncan Gaswaga, judges, and Robert Eno, registrar. After deliberation, the court renders this judgment. I begin with the facts of the matter. It emerges from the record that on the 17th of January 2014, the applicant, a bishop of Tanzania Field Evangelism Church, allegedly raped a 16-year-old girl. The applicant was arrested on the 2nd of February 2014 and charged with the offense of rape. He was tried and on the 14th of August 2015, convicted of rape and sentenced to 30 years imprisonment by the District Court of Yamagana, sitting in Yamagana, Mwanza District, in criminal case number 33/2014. The applicant then appealed to the High Court of Tanzania, sitting at Mwanza, in criminal appeal number 119/2015, which on the 14th of December 2015 dismissed the appeal. Dissatisfied with this decision, the applicant appealed to the Court of Appeal of Tanzania, sitting at Mwanza, in the criminal appeal number 94/2016, which on the 18th of October 2016 dismissed the appeal. The applicant further filed an application for review at the Court of Appeal of Tanzania at Mwanza, criminal application number 6/08 of 2017, which on the 9th of July 2018 dismissed the application for review. I proceed to read the prayers of the parties. The applicant prays the court to one, find that the respondent state violated the applicant's rights provided under the charter, order the respondent state to restore the applicant's liberty by releasing him from prison, order the respondent state to pay the applicant reparation in the sum of 500 million Tanzania shillings for moral damage, order the respondent state to pay the applicant reparation in the amount of 366,500,000 Tanzania shillings for loss of income, order the respondent state to pay the applicant's reparation in the amount of 100 million Tanzania shillings for life expenses, Order the respondent state to pay the applicant reparation in the amount of 8 million Tanzania shillings for secondary school education for 2 children. Order the respondent state to pay the applicant reparation in the amount of 20 million Tanzania shillings for college education for 2 children. Order the respondent state to pay the applicant reparation in the amount of 150 million Tanzania shillings for service to the church and fellows. Order the respondent state to pay reparation in the amount of 50 million Tanzania shillings for costs incurred by the applicant on transport. Lastly, order the respondent state to pay the applicant reparation in the amount of 166,500,000 Tanzania shillings as compensation for affecting his properties. With regard to jurisdiction and admissibility of the application, the respondent state praised the court to order that the court has no jurisdiction to act as an appellate court towards the grounds of appeal pronounced by the applicant. Secondly, that the applicant has not met the admissibility requirement as provided by Rule 39(1) of the Rules of Court. Thirdly, that the application be declared inadmissible. Fourthly, that the application be dismissed in accordance with Rule 38 of the Rules of Court. And lastly, that the cost of the application be borne by the applicant. With regard to the merits of the application, the respondent state praised the court to order that 1, the respondent state did not violate the provisions of Article 3, Sub 2 and 5 of the Charter against the justices and rights of the applicant. 2, that the application be dismissed for lack of merits. Thirdly, that the applicant continues to serve his sentence. Fourthly, that the applicant's prayers be dismissed. And lastly, that the cost of this application be borne by the applicant. In response to the applicant's submission on reparation, the respondent state praised the court to 1, dismiss the applicant's prayer for reparation in its entirety with cost. 2, grant any other relief the court may deem fit to grant. I now proceed to read the operative part of this judgment. For these reasons, the court unanimously on jurisdiction dismisses the objection to its jurisdiction and declares that it has jurisdiction. On admissibility, the court dismisses the objection to the admissibility of the application and declares the application admissible. On merits, the court holds that the respondent state did not violate the applicant's right to be heard under Article 7, Sub 1 of the Charter regarding the allegations that the evidence upon which the conviction was based was not properly examined and evaluated. Equally on merits, the court holds that the respondent state did not violate the applicant's right to equal protection of the law under Articles 3, Sub 2 of the Charter in respect of the unsubstantiated allegation by the applicant to that effect. The court holds that the respondent state did not violate the applicant's right to dignity under Article 5 of the Charter in relation to his allegation that upon his arrest, he was treated inhumanly. On reparation, the court dismisses the prayers for reparation. On cost, the court orders that each party shall bear its own cost. This judgment is signed by the bench as earlier mentioned, and Robert Eno, the registrar. And it is done at Arusha this 13th day of November in the year 2024 in English and French, the English text being authoritative. Merci, Monsieur le Président.
Telle est la décision de la Cour. Le rôle étant épuisé, l'audience est levée.
Oh.